Okay, so guys, such a great participation here. Thank you for being here. Let's give a start to this outstanding panel. And the topic of today is data protection, impact assessment, and risk-based regulation in data protection. I'm Stefano Leucci. I'm a fellow researcher at the Nexa Center for Internet and Society of the University of Torino in Italy. And I will just set the stage and I will leave the floor to our colleagues here. We have such a lot of points on the maps when we talk about impact assessment and risk in GDPR, in data protection, let's say. And I would like to start from an experience I had such time ago relating to a new system that I was working on related to, let me say, automatic credit approval and biometrics. When I joined the company and I started, giving around a look to what was happening, the system was launched and was perfectly working. Everything was so happy of this fantastic tool working autonomously without any kind of problem. And all of a sudden, something started happening. The system started to approving credit dossier and non-approving other credit dossier. The system starting avoiding people enrolling in the process and so on. And so as a data protection officer, I went in front of my colleagues and I said, guys, okay, let me see the risk analysis we've done about personal data management. And they give me a wonderful security analysis, no? And so I went back again saying, guys, okay, what about the privacy risk scenarios? And they give me again the same analysis. So I understood we need to work more on this topic. We have huge problem when we have to set out, let me say, differences between different kind of risk in organizations. Banking sector, I'm used to work within, financial sectors are full of risk management techniques, full of risk management tools we all use in our daily life. And I have the perception that we have to correlate and integrate all those tools. We are not just talking about compliance risk. Data protection, risk-based regulation is something new, but it's kind of a different risk we have to work on. And the point we have here is that we have huge, let me say, areas of working that is absolutely unexplored in my opinion. And the great thing is also that we have here all the panelists to work on all those different points on the maps that we have to explore, and let me say, at least the most important. In fact, today we will go through, firstly, we will go through an interesting analysis of what AI has to be understood from a risk-based point of view, and thanks to Reuben. We will move then to Michael, that will explore a bit let me say, processes that has to be understood when data protection goals will be implemented inside systems. We will go through Zoe, that will give us an experience about how the DPB, the European Data Protection Board, is moving on this topic in order to regulate and manage our European, let me say, evolution through this world. Then Andrea will give us the chance to understand how a company is moving on this topic, how processes are to be designed, and finally Katerina will give us an insight about the role of risk in GDPR and general data protection regulation. So I will leave the floor to Professor Hildebrandt, our moderator, and I will stay here moving slides. Thank you.
These are great mover. So I frightened the hell out of everybody by saying that everybody gets only 5 to 7 minutes, because I think it's very important to have some interaction between the panel. And we have 5 speakers, that's quite a lot, and then to keep time for a Q&A with you, the audience. And it means I'm after those 5 to 7 minutes, I will put one quick question to keep it a bit lively. So I'll immediately now give the floor to the first speaker, Reuben Binns, Oxford Computer Science and ICO at this moment in the UK.
Thank you. Just to briefly disclaim, I'm going to be speaking here in a personal academic capacity rather than on behalf of the regulator, so apologies if anyone was hoping for nuggets of advice there. So yes, a lot of the work I do is around machine learning and the risks that arise from applications of machine learning. So you might be wondering, well, what is that? So machine learning, you can think of it as a way of instructing a computer to learn from patterns in data sets to classify or predict new instances of things it hasn't seen before. And so it's worth sort of recalling that one of the reasons for including data protection impact assessments in the GDPR was due to the risks of these kinds of technologies. So I'll give you a few examples. So imagine you have an employer who is sitting with a large number of applications for jobs, and they want to build a model that will help them predict how well new applicants to a job will do when they're on the job. So they have historical data that shows the performance reviews, for instance, of previous employees, and the aim is to give a score to new potential employees. And if the historical data that they're using, let's say, reflects gender discrimination in the workplace, you may well see that the performance reviews of women were given disproportionately lower scores, and that will be reproduced by the model that's being used. And there might be cases where there's no kind of social discrimination in the data set, but the data set is just imbalanced, so there's a minority group which is underrepresented, and therefore the model will perform worse on them. It could be perform worse to their benefit or to their detriment. Another example, which is not something that we traditionally think about in data protection, would be something like automated content moderation. So if you think about a system like Google's Perspective API, this is an API which has sitting behind it a natural language classifier, which is trained on a large number of comments that have been labeled by humans as being offensive, abusive, or toxic, which is the language that they use. And this API is available to third-party websites to run any kind of text through and get back a score. And so if you, let's say you were a news media organization, you had comments underneath your news stories and you wanted to, you didn't have the resources to moderate them by humans, you might consult this Perspective API and it would give you a score for each comment as to how likely it is to be perceived as offensive. And you might use that then to either automatically remove those comments. You might assign a score to certain users of the platform, and after a certain threshold they might get removed or warned. And these kinds of systems are ones where you can imagine that there'll be traditional data protection concerns around the comments that are used to train the system being potentially personal data, concerns around profiling, so applying a toxicity score to a user. But really the sort of the ghost in the room is freedom of expression. That's the fundamental right that you might be worried about. And so traditional data protection approaches might not necessarily allow a data controller to consider those more broad, holistic, fundamental rights like that. And then a final example I'll give is one where the risk is one that would very traditionally be seen as part of data protection, but the method of identifying it would probably not come from a traditional approach to data protection. So there's a lot of recent research at the intersection of machine learning and cybersecurity, which challenges the traditional assumption that if you have a bunch of training data, you apply a learning algorithm and you get a model out, and the model represents patterns in the data, but it doesn't contain the data itself. But it turns out that even well-built models often remember parts of the training data that they were trained on. So if you have a natural language classifier which is trained on a text corpus which contains credit card numbers or phone numbers or other personal data, it's possible that an attacker, merely with access to the outputs of the system and to be able to run queries on the system, might be able to retrieve some of the training data that was used to train it. And that's an example where you might have completely compliant data collection for the training data, but you wouldn't necessarily have anticipated that by releasing the model to external parties that you might be revealing personal data. So I think as well as these examples where a DPIA can help identify the risk, it's also a good vehicle for identifying safeguards to mitigate risks. So it might be that, for instance, in the gender discrimination in employment hiring algorithm, you can think more broadly about the kinds of technical or organizational measures that you might use to guard against that. Similarly, with the automated content moderation, you might think about things like due process and safeguards that allow people to challenge if their accounts have been blocked on the basis of these toxicity scores. So I think there's the ability to not just identify these risks, but also to identify safeguards that are more holistic, that wouldn't necessarily come out of the traditional rights and obligations of data protection.
Whoa, 1 minute within the time, my God. Thank you very much. One quick question. In the current legal obligation, other than in the draft, there is slightly less attention for getting people involved, the people that are going to be targeted, for instance, that are running the risks. I developed in some paper the idea of agonistic machine learning, which I think you've seen. So how do you think it would be possible, in a practical sense, to involve in a DPIA the people who are going to suffer the consequences of the data processing operations?
Thanks. Yes, I mean, I was kind of slightly disappointed to see how the provision to require to consult data subjects or their representatives was slightly diminished in the drafting. But I think there is still that provision there, and I think there are lots of interesting models that are being developed at the moment about participatory algorithm design. I think there's a danger that people are consulted merely as a way of co-opting or rubber stamping things. So I think there has to be the genuine possibility that whole programs are redesigned or even not pursued on the basis of those consultations for them to be meaningful. So there are certainly challenges there, but there are lots of interesting new models that are being tried out. So with the ICO, they've started trying out citizens' juries. So those kinds of models might be interesting ways of including affected stakeholders in the.
Can I follow it up with a very brief question? So in the machine learning research design, there are all sorts of design decisions that are quite, that have huge consequences and usually trade-offs. So where would you think, at which design decision would you think this input from people who will suffer the consequences is the most important or is possible?
So I think it probably would depend on the system, but I think data scientists are not necessarily good at understanding the nuances of the predictor variables that they're using and the target variables. So the target variable might be the performance review, which might be a score in an employment setting. A data scientist coming in might not understand, the context of how that thing is created, whereas someone who's either been involved in the process of scoring an employee or the employees themselves might have more understanding of the nuances of how those variables can be misleading in different ways.
Fantastic. Thank you very much. Michael, the floor is yours.
Yeah, thank you, Mireille. Now from the specific more to a methodological point of view, as you know, Article 35 is not very specific in how to implement a data protection impact assessment, and that's something that I and my team are currently working on to make DPIA schemes work in practice. And we are facing a couple of practical problems, and I'm going to present to you a way we have developed to bridge a gap between the more legal approaches as it is in the legal text and the more technical understanding of those who finally do the DPIA. So in general, for most legal scholars, probably the terminology used in the legal text is quite obvious, but and it's shaped by the discourse that the community is doing. So it's very clear what the terms mean. But if you go out to those who carry out the DPIA, which normally is not the lawyer, probably not the DPO who is supervising the process, but to the competent department who is developing the applications and the development processes, they are not legal experts. And if I come with this quote from the legal text saying that risks for rights and freedoms, what are rights and freedoms, of data subjects, do you mean customers, do you mean employees, blah, blah, blah. So what the heck is the legal text talking about? And do you have an idea how we can comply with this text in terms of code that we are going to produce? And in the end, as I said, it must be those who really have the knowledge of the processing that need to know what they have to assess in that respect. So how can we operationalize the principles from Article 5? And I'm only talking about Article 5 and not, well, for instance, Article 6, if there is a legal basis for the processing, to set these people into the capacity to do that. The good thing is that skilled engineers they pretty much know how to deal with risk management, at least in the context of classical ISO standard IT security management processes. And we aim with making use of protection goals, this kind of skills that we have, and it enables people without a lot of extra learning to come into the process. Of course, you have to be aware that the knowledge from IT security does not lead to confuse impact assessment, privacy risks with security risks. That's something that we already had when we discussed this panel before. So that even the IT security goals have to be dealt with from the data subject perspective. So the starting point then is, of course, the traditional security protection goals as we know them for decades. And as I said, that engineers are usually familiar with, have to be thought from the data subject perspectives, and of course you have to make clear to technicians that this is nothing that can be seen only from a technical perspective. They have to take into account the data, the systems, and also the processes, the organization around that. I won't talk about these three goals, but on the three protection goals that you need to complement that picture and to make sure that not only IT security but also the data protection things are covered. And these three extra goals, developed by late Andreas Fitzmann and the colleagues from ULD, include unlinkability, transparency, and intervenability. Just briefly, unlinkability means that the privacy-relevant content cannot be linked across domains that are constituted by a common purpose and context, which is, of course, again, relatively abstract things, but then you can break it down into terms that engineers often understand. In other words, it's data minimization, it's necessity or need-to-know practices, purpose binding, separation of powers, and things like that. And you can go even further and say there are typical implementation techniques available to make sure that these things happen. So in the end, you have a catalog that may aid engineers to see if they have focused their interest on the right problems, and if they have taken the right measures to address these problems. So for linkability, there are techniques such as, well, data avoidance for the data minimization principles, generalization stuff, separation, isolation, and so forth. Okay, second principle, transparency. The property that all data, that all privacy-relevant data processing, including the legal, technical, and organizational setting again, can be understood by the data subject at any time. So, well, that again can be broken down into some more graspable things: openness, accountability, reproducibility, and again we have a catalog of implementation techniques such as logging, user notification, dashboards, privacy policies, blah blah blah. And the sixth principle then is intervenability. Data subjects know what's being done, and then we have the property that data subjects can intervene and say, well, in all possible things, ongoing, planned, privacy-relevant data processing, so that they have user controls, rectification, erasure of data, and all the things that we pretty easy link to the Article 5 principles. One thing to take into account is that you cannot reach 100% in each of the principles. There is always a conflict of goals. For instance, there is a conflict between integrity and intervenability. Integrity says, well, no changes, please, while intervenability offers the possibility to change data if the data subjects wish so. And you can do that for all these principles here on this star. So doing an assessment always means to bring them into a certain balance. So making use of privacy protection goals is a way to make use of knowledge engineers have and to bring them into a systematic and all-embracing discussion about what they are doing and if certain risks are taken into account.
Okay, Michael, thank you very much. I think that gave a lot of very practical, more detailed, hands-on tools. So, correct me if I'm wrong, I'm now going to think of AI systems, so machine learning systems. And I have the feeling that this is because of, for instance, the unlinkability principle, some transparency, is more focused on hiding data, preventing data from being gathered. So I want to look at the DPIA on the other side. So once you have a legal ground and you have done your data minimization and you have a wonderful targeting, micro-targeting system in place, and you have collected informed consent about additional processing, you never know, maybe it's possible. And you begin to target people. So how do you give data controllers at the same level of practicality and effectiveness tools that go more into what Reuben spoke about? Is it necessary now to bring in techniques that come not from, let's say, the Pfitzmann-Hansen way of looking at data, though that I think is preconditional, but from the machine learning, critical machine learning community, and how could that fit in, just very briefly?
Yeah. First of all, I don't think that DPIA, as it's formulated in Article 35, is the best way. You already mentioned the involvement of data subjects, and there are certainly things at the edge of technology development which are difficult to handle anyway, even regardless what kind of criteria or methods you are using. And maybe some of you know that I've been working on privacy impact assessments even before GDPR, and I still believe that some of the elements in these earlier schemes still have their benefits in order to reveal risks that, as you mentioned them. And I think we have to see how the practice is really evolving, because the Article 35 text is not really to the point. So if you're quite positive about that, you can say there is a lot into that, especially the term that you have to assess risks to the rights and freedoms, not just data protection, rights and freedoms, very broad, is something that, well, of course you could say, well, the industry is probably doing what they are obliged to do up to a box ticking scheme, but in that respect, I would say there are a lot of things that you can discuss to reveal this kind of risks, and that are even useful for the companies, the public authorities, doing a more extended way to carry out DPIAs and make things useful for them.
Yeah. Okay. So basically, we're linking this back to the more ethics approach, ethics by design. Yeah. Okay. Very good. We move on to Zoe, EDPS. Oh my God, did I say EDPS? No. That's actually what I wrote down. EDPS. We're getting so acronymized here. Yeah. Sorry, apologies. Something totally different, isn't it?
Okay. So, first slide. Goodbye, everybody. Good morning, everybody. Not goodbye. Goodbye, I will say after a half an hour, I think. So, what was the EDPB's work on the DPIA list? The EDPB was involved in that activity because it has to consider and assess the national list of the national regulators which provide for which processing activities may constitute a high risk for the data subjects, and therefore the controllers shall conduct a DPIA. So up to now, the EDPB has considered 28 national lists by 28 national DPAs, which was a big challenge on the one side because there was a big variety in the list, but on the other side it was also a benefit, having to consider in the first bunch 22 national lists. The EDPB was able to make a global assessment and easier identify common criteria. Next slide, please. Everything. So what are the other anchors? What are the anchors that the EDPB has moved through? The first is that purely processing activities, they are purely local, so only confined in the member state of the national DPA. These are not included in the assessment of the board. Why? Because only DPIA lists that have a cross-border character, they come to the consistency mechanism and be assessed by the board. Second anchor, the GDPR does not require one common EU-wide national list of processing activities for which DPIA should be made. On the other side, the national list should be consistent to each other. Therefore, the DPIAs may produce their own list, but this should be considered this should be consistent, but not having only one unique list. Third anchor, the risk for which a DPIA should be made should be a high one, not a moderate one, not a low one. And the risk, as also the panelists said before, should be a risk to the fundamental rights and freedoms of the individuals, not the risks of the controller as it would be if his system are affected. By the way, this may be also a risk for the data subjects, but in this context should be considered whether for instance, an availability issue is also a risk to the data subjects' rights. And the fourth anchor is that the lists cannot be of exhaustive. Why? Because the risk is dynamic, evolves over time. The GDPR asks the controllers to assess the risks. It is itself, the GDPR includes some criteria, some cases, what could constitute a high risk, but this is only an indicative picture and not the whole picture. And the fifth and the last anchor that the EDPB used is that we should have as a baseline, all the national lists should have as a baseline the 9 criteria developed by the Working Party 29. So, therefore, the lessons learned is that 4 sets of rules have been developed and are applicable throughout the national list. First set of rules, a core of processing activities should be found and be included in all lists. This is activities that they relate to genetic and biometric data, but not every processing of biometric or genetic data constitutes a high risk unless this is combined with one more criterion. Second rule, the large-scale processing activities cannot be quantified. So in lists where DPIAs have said, for instance, when a processing activity covers 4% of my population. No, this is not quantifiable, and this has several reasons that we can maybe discuss later. Third type of rule, some types of processing operations can be used only if combined with another criterion as set out by the Working Party in the guidelines for how to conduct data protection impact assessments. Such criteria that need to be combined is, for instance, processing of location data, use of innovative technologies, processing collected from data collected from third parties, processing for historical and scientific purposes without consent, processing where data subjects are deprived from their right to information, etc. And the last rule is that some processing operations, as suggested and included in the draft national list, cannot constitute a criterion to identify high-risk processing operations and cannot be used as such or in combination with another criterion of those that they are listed in the Working Party 29 guidelines. As, for instance, on data transfers, international data transfers. This is not a criterion which may constitute by default a high risk for the data subjects, or implantable devices without anything else. Or the processing activity based on legitimate interest, so that where the criterion is the legal basis of the processing. As a result, these opinions, they led to a sort of convergence. They have used the Working Party 29 criteria as baseline, but indeed, a variety of combinations may appear in the national list, as the criteria may combine either one-to-one or one-to-many. So the total amount can be a big one. How big it is, one may study, because there are DPAs that they have used, for instance, criteria that seem differently, but they are not for such differently. For instance, if one DPA said the processing of biometric data for the purpose of uniquely identifying an individual, and when innovative technologies are used, includes also employees' data. Another DPA can have used the same processing activity of biometric data in the employment context. These two then are not too far away from each other. So we need always to really study how the criteria are applied in the national list to find out also how big the variety in the processing operations is.
Okay,
Thank you.
Oh, fantastic. Immediately, the question, what if a national DPA does not follow the guidelines?
Yes, for this there is a procedure in the GDPR, since the EDPB has issued opinions and has recommended, and not only recommended, the DPAs to do some steps. For instance, to remove some criteria, to put the core set of rules in their lists, etc. If the DPA, then the DPA has to communicate to the board the final list that it intends to approve and whether it follows the opinion. If this opinion is not followed, then the so-called consistency and dispute resolution mechanism shall be followed, which then will resolve the issue, and I think in favor of the consistency. But up to now, the 28 DPAs, and this is good, have followed the opinions of the board.
Okay, fantastic. Level playing field. Thank you very much. We're moving on to Andrea, who's working with Oracle.
No? Can you hear me? Okay, so thanks for the attendance. And then before we go into the presentation, 2 remarks. I'm also equally to Reuben's. I'm talking on my own, so views presented today are on my own, and I'm not representing today not Oracle, not previous employers. And then also I will try to be very schematic because, yeah, you have heard that we have time restrictions. So I think that there was a moment like practitioners were left alone with implementing GDPR. Some of the requirements are more challenging than others, and if I have to choose one that really proves to be difficult from legal text and the document of GDPR into practice is the Article 35 on data protection impact assessments and how you bring that requirement into practice and in a proper and adequate control. So at least also like for me, like really like the core was having a process that could be workable in a company while also like really raising the level of awareness and getting this as a wonderful opportunity to strengthen rights and freedoms of individuals, to get better understanding in the company of why they should care and they should really buy into the idea that this is beneficiary for the company and for society as a whole. So this is at least what I think that practitioners should be really looking at when looking at the requirement of Article 35. And then now talking on the challenges, many can be said, but I think that I'm going to just present around the what, so basically like the notion of risk and the challenges around using risk as a criteria and the concept of risk. Challenges around the who, so who is behind these assessments, who is performing these assessments in a controllers' organizations and how that influenced the assessments. And then challenges also around the how and when, which revolve around methodology, operations, when is the best timing to perform a DPIA, what tools should you be using. So those are the 3 types of challenges. When going to the what, so basically the concept of risk and using risk as a criteria to assess, is not exclusive to data protection, so I think that this is a concept that is used in other risk management frameworks, but I do think, and I agree with Michael's point, that in the context of data protection, many has been done as an in-house lawyer to really unlearn and to undo many current practices. So people were used to looking at risk from perhaps a security perspective, perhaps a compliance perspective, and then this was huge, massive exercise about this is new type of risk, we need to broaden the scope, and we need to understand concepts, but for non-legal audience are difficult, like fundamental rights, also like soft risk, like autonomy. So there is massive exercise on awareness that needed to be done. Then also when you think of the risk, how you are going to quantify it, how you are going to measure probabilities, you need to make tons of decisions. So are you going to go for percentages? So you are going to tell people, measure in percentages of like 5%, 10% of likelihood and impact? Are you going to use wording, so qualitative kind of like way? Are you going to tell people use likely, unlikely, and probable, probable? all those things, when looking around and testing the models with people, they do play a role. And as I said, it's not exclusive of data protection, but you do need to consider when designing the program. And then also, interesting enough, if you ask also people to judge risk, you may get one outcome. But if you ask people to judge risk versus benefits, especially when assessing new technologies, then you also see people more prone perhaps to assess towards benefits instead of towards risk. So those kind of things are decisions that you do need to make also like when designing the process, because the outcome, I have seen that it can be really tremendously different. And then also, as I said, thinking if you can learn perhaps something from other risk frameworks that have been around for a while and how you can reduce and recycle. So that on the concept of risk itself. On the performance of these assessments and who is behind, I think that different organizations have different models. So some people are relying more on the business, some people do get support to assist the business in those assessments. But what it does come to me, no matter what, also even if you're talking to only lawyers or to compliance officers, it is really the emphasis also put by regulators on the objective assessment. It is really difficult not to think how you are going to get that level of objectiveness throughout a company, because I think that is obvious also in other areas that risk perception is there. I mean, we do have a subject element that you do need to consider and tackle. There, like, culture plays a role, the understanding that people have of the technologies, the emotional factors. So also, like, for instance, how much we have read in social media about certain risks, how much that influenced the way that we assess. And then also, then as a lawyer, you then need to think perhaps how you are going to tackle those subjective sort of bias, perhaps indeed how you can correct, how you can standardize like the playing field, because it cannot be also that you may have one organization having a similar processing activity judged completely different. So that is also something. And then last, around how and when, we have heard as well, this is like a risks are mobile. There is a dynamic factor that you do need to grasp, and I think that organizations really need to also like step up and perhaps move from the traditional way of looking at risks with a paperwork sort of a tick box approach. But I am strongly like advocating also for the use of like tools that do basically facilitate the interaction with the business, tools that are able also to get better understanding of the efficiencies, inefficiencies of the process, how people are looking at it. So if companies really are thinking of like how to do this right, I do think that tooling and having a systematic approach, it is needed. And the other, I think that big headache in terms of like challenge, and then understood as a positive challenge in the sense of you do need to come up with a nice legal thinking, is on the clustering of DPIAs. So we have seen also from regulators that we perhaps may have one DPIA covering multiple data processing activities. But the question is also like how do I know that perhaps a DPIA at a system level is it enough, or have I gone too high level that a regulator will still expect me to go per processing activity, so the whole DPIA on the system it may consider invalid. So that was it, and I think that with this I pause, and perhaps there will be more in the discussion.
Yes, I'm going to ask you a question. It's another question than I thought of last night when I prepared the questions. But I suddenly thought this is about Oracle. So Oracle is doing repurposing, is working with a lot of data that have been collected originally for a specific purpose by another company or whatever. And that poses a lot of challenges. So in terms of lawfulness, but this is not what we are now talking about. I'm very curious how a company like Oracle or other data brokers connect with the data subjects who are like a couple of steps removed. So how could such a company, and there are a lot of them out there that are doing secondary processing, connect with their data subjects to, and I don't just mean to use technical tools to to profile them and to see what they think about it, but to really get together like the citizens' jury idea. So how could this be integrated into the DPIA, because I think also because there are some issues with the lawfulness of the secondary processing, it might help immensely if these data subjects get involved at that level.
I appreciate the question. So if you don't mind, I'm going to reformulate it differently in the sense how companies in generally may be involved data processing, data subjects in the data processing assessments. And there I think that you see companies doing different things. Also, like when talking to other practitioners, you see companies that perhaps if we are talking about how to, if it's a processing activity that involves employees, do you want to do it directly with your employees or do you want to do it with works councils? If you're talking about data subjects but you do not have a direct relationship with the data subjects, is it perhaps then good idea that then you go to a sort of like focus group, like companies that are working on research, that they are working on how individuals are feeling about a particular technology, that they organize some sort of like surveys and processes for you, and then also like how to have the views of the data subjects. There is also, and I think that there's a lot also of organizations that are acting as intermediaries also like to help to conduct that discussion, and you can even have them per sector, per industry, that are helping also to implement code of conduct, frameworks, so that also like the understanding of companies plus the data subjects are somehow understood and the dialogue is there. And then in the cases, I have seen also like companies while they are doing certain research that they do have the direct relationship with data subjects and that they do go and ask and get the direct feedback.
Yeah.
So
okay, very interesting. So there is a whole field, like a discipline on participatory technology assessment, which has been working with things like citizens jury and focus group, where one of the foci of that discipline is who is raising what question, because in the framing of the question, I mean, focus groups are also used to talk about toothpaste that sells better, right? So peanut butter, taste this and what you think of it. So it would be fantastic if into the DPIA development, maybe also at the level of the EDPB, not to be confused with the EDPS, we get that knowledge in, because it's been around now, I think, for 20, 30 years, and there's a lot to learn. Yes, Michael is saying, okay, let's go to our last speaker, who is also the initiator of this panel, who also brought all of us together. So, Katerina.
Okay, now it's good. Thank you very much. I'm Katerina. I'm a PhD researcher at the Radboud University, the Netherlands, and my research topic is about the concept of risk in the legal obligation of DPIAs, but more generally also in the GDPR. So I will begin this presentation by directly highlighting my main point, and this is that the concept of risk under the GDPR should not be understood as a non-compliance risk, meaning that risk that the processing operations are not compliant with the GDPR. So, of course, we do have the wording in the GDPR that is about risks to the rights and freedoms of data subjects. And also, Zoe already mentioned that one of the anchor points of the lists is the fact that the risks have to be assessed with regard to rights and freedoms from the perspective of data subjects. But I would like to also accentuate the point by looking into the role of risk in the GDPR. Stefano? So for this, I will begin talking about the principle of accountability, which we find in Article 5.2, and it talks about ensuring compliance and being able to demonstrate compliance with the data protection principles. Now, these principles have been said to constitute the essence of the fundamental right to data protection. What is the point here is that the principle of accountability is not a new principle in data protection. However, it should be mentioned that it is an enhanced principle under the GDPR. And why this is the case, we find it in the general obligation for data controllers in Article 24, where it actually says that the measures should be taken into account the risks. The risks, nature and scope should be there in order to ensure compliance and be able to demonstrate compliance. But this is also apparent from specific obligations that we have in the GDPR. For example, data protection by design, or the panel's subject, data protection impact assessments. So we acknowledge an enhancement of the principle of accountability under the GDPR, and this leads us to a further remark, which is the fact that it testifies to a modified compliance scheme. Now, what I mean by modified compliance scheme is that these obligations actually put in place measures, mechanisms, and tools that establish a proactive approach and also add scalability. So in that way, they implement accountability and they ensure compliance. What is prevalent in this compliance scheme is the position of the concept of risk. So the concept of risk is actually the chosen as the most appropriate criterion that leads this compliance scheme. It enables accountability by adding scalability to the legal obligations, and in that way it actually serves a more effective compliance with the data protection principles and therefore data protection. We should understand that the so-called risk-based approach, in the heart of which is the concept of risk, is actually a legal strategy in place so that it serves the rights base, the fundamental rights nature of data protection. So it's there as a strategy. This is I will close with 3 main points that I want to make. So by acknowledging the concept of risk as a concept in order to achieve effective compliance, we can understand that giving it the limited scope of non-compliance, we run into a circle. And also by having demonstrated this compliance scheme, the modified under the GDPR, I would say that the risk of non-being compliant with the GDPR is dealt with this exact compliance scheme introduced. And my third and last point is a more methodological one, which is by identifying the role of risk and of a concept in the data protection legal framework, we can come to some results with regard to its scope and to how we could interpret it.
Thank you very much.
Am I on time?
Oh, yes, you are.
Okay.
On the dot, it's incredible. We all were. So, to put it a bit on edge, could a controller be held liable for violation of other fundamental rights, even if that controller, in its processing operations, did not violate any specific GDPR obligation, apart from those that specifically say, so is the controller ready if he complies with Article 5 and Article 6 and some right to object and erase and all that sort of what some people think are checkboxes? I don't think so, but some people think so. If all those boxes have been checked, but it is clear that a violation has taken place of non-discrimination, for instance, freedom of speech, does that mean that that controller is now liable if they did not foresee this when they did the DPIA, though it would have been foreseeable? And the wonderful example is, of course, Cambridge Analytica, where Facebook said, well, we put it in the contract.
Yeah.
They were naughty. If that obligation had been there, then you could say, well, you should have checked it. It was a clear risk. So
so I will use the example of the DPIA. So to comply with this legal obligation, we see it also in the Working Party 29 guidelines that have now been endorsed by the EDPP, that actually, in order to comply with this obligation, you need to do it correctly, otherwise you infringe it. Now, correctly means that you have to have identified and assessed and mitigated the risks to the rights and freedoms. So that means that you have infringed the provision if you have not identified these risks. So for sure, the answer is that you have not been compliant with this obligation and that you have infringed it.
Okay, yeah, there's a small circle here, but
Yeah.
it's totally clear what you're saying, right?
Yeah.
So just complying with Article 5, 6, 7, etc. is not enough. Yeah,
Exactly.
okay, great.
Yeah, the perspective is broader.
We have all kinds of hugely interesting questions, which I'm first going to throw into the panel. I'm going to throw actually 2 into the panel, and then I think we go to the floor. That is then yours. So, yes. When I hear Andrea and Zoe, I heard Zoe say that as regards the criteria, pure quantified criteria is not allowed. That's at the level of these sets of rules, right? When I heard Andrea, I heard a lot about quantification of risks. Now that's not at the same level, but I am very curious how this exclusionary rule that Andrea put forward, that Zoe put forward, that exclusionary rule that says, okay, you can't just say every time 4% of the population has a risk, you have to do a DPIA. So this is, the question is what's behind that exclusion? And then Andrea saying very practically, well, we have to do a risk assessment, so we're going to quantify a whole lot of things and then make decisions. So I'm throwing this towards the 2 of you. Maybe you can respond to each other, not to me.
Okay, so let's take the view of the EDPB when I considered this sort of criterion. It was about some DPAs that they have tried to specify what large scale is by using only the aspect of number, either as an absolute number or as a percentage of the population. What the EDPB said that this is not the correct way to define large scale. Why? Not because this quantifiable aspect cannot be used, but shall not be used on its own. It should be considered in the context. So there are other aspects to consider, as for instance, the categories of data processed, the different sources from where the data are being captured, the geographical extent, is that covers the whole country, is it cross-border, is on a region. So it should be a conglomerate of different aspects.
Yeah, so when I was meaning on the quantification, I think that first there is no question on the criteria, so there is no quantification. I advocate basically you need to have like the criteria in mind. That can be the Working Party 29 guidance, it can be 1, it can be the 2. You need to have always that, but then indeed there is the moment where you do need to assess also what is the status of the processing, how you can mitigate, what safeguards you have implemented. You have to go one by one against all the risks that we are discussing now, that they are broader than data protection. So there is a moment where you need to reassess even and say, okay, have you done enough to mitigate the risks? And there is where on the evaluation part, you do need to choose a framework, which can be a combine, can be percentage, can be like wording, but then from the term high to really say whether you are still high or you are low, something you need to use. But for me, the criteria itself is not questionable. So for initial point is always criteria, and then there the quantification comes on the mitigations and on the assessment of the risk.
So on the safeguards,
Yeah.
not only on the
Yeah.
notion of the risk.
Fantastic.
And this makes a difference.
Very interesting clarification. So I'm now just curious where I had the impression, maybe I'm wrong, that Michael, you were focusing, at least with the framework, on compliance with Article 5. Katerina is saying, well, that's not enough. You actually already mentioned sort of an argument that one could learn from what has been done in the past in terms of extending. That was an ethical thing. We're now talking about a legal thing. So how could you extend your, I think, very practical model, which is very important, to what Katerina is talking about?
I would a little bit disagree that it's on
nice.
compliance only. But on the other hand, if you are dealing with people who actually have to comply with something, you always have to argue, why should I do that?
Yeah.
I'm very much in favor of having an extended scheme with data subject involvement, with a linkage to privacy by design in very early phases of development and stuff like that. But in the end, this, especially the data subject involvement, is a very costly thing. Well, you really have a tough job to say people why this is really worth the investment. So that maybe gives you the impression that I would be very happy if in the first instance the DPIAs could show compliance, but real compliance, not just the light compliance,
Tick boxes, yeah.
the tick boxes that we've foreseen. And as I already said, I think there is enough room for maneuver within the existing text from the DPIAs also, because they in the end have to say what they want to see. By saying, well, you have something which is so heavily infringing or affecting people, and you have not even made the attempt to seek the views of the data subjects, and I think that's something that can evolve over time.
Okay, I'm going to push that question to Reuben and reframe it slightly. So, would it be possible to take this assessment requirement concerning fundamental rights, risks of fundamental rights and freedoms, into the principles? And I'm specifically talking about machine learning, and let's pin it down again to the Cambridge Analytica situation. So, could we read Article 5 in such a way that you actually bring that risk in to Article 5, and based on that, require at that very moment then, if that legal obligation had been applicable, you should have proactively foreseen that this risk was there. Can you bring that into Article 5? What do you think?
We'd have to give that more thought, I think. So the argument is, had Facebook been doing a DPIA on that particular collaboration with that particular developer? I mean, I assume probably if there was one done at all, if maybe there wasn't, it would have been at the level of we're going to invite developers into the platform, and that would be one level, and then there would be individual level ones with each developer. I think that would be a good approach. Obviously, in reality, that wasn't what happened. Yeah.
It's actually a matter of precaution, yes.
Yeah.
So I would like to give the floor to the floor. Yeah. Can you introduce yourself briefly and also say to whom you want to address your question?
My name is Walter van Holst, and I have two questions. One for the general panel. And that one is basically, if you look at the text of Article 35, it presumes a full or fairly complete design of the processing envisaged. So basically a waterfall-like blueprint of the systems that are to be built in the future, whereas the current trend is towards more iterative methodologies for developing IT systems, and there's a tension there, and I'm wondering whether any of the panel would have thoughts on that.
Agile software.
Basically that. Yeah. And the other is specifically for Zoe. There are quite a few methodologies around, quite often by industry groups, trade associations. Quite a few of them fall clearly short of the text of Article 35. And that is a negative influence because they end up having arguments while executing DPIAs by the methodology you're using is so much stringent, so much more thorough than the model used by this and that trade association or this group of governmental organizations. And I'm wondering to the extent to which that is on the agenda of the EDPB and what they may want to do about that.
Okay, yes, please.
This question. I do agree that there is kind of a tension between that, but that's a tension that exists for all kinds of technology assessments in general. Either you are too early and you don't know the specifications well enough to make a justified assessment, or you're rather elaborated in your designs and you make an assessment, but you cannot change the designs anymore. Nevertheless, DPIA is not a one-shot activity. It's really a cycle of things. Maybe the 2 to 5 years that I sometimes heard in the discussion process of the GDPR to repeat the DPIA is too long for agile software development processes, but that's probably something we need to think about when we really define the methodology. But the really important thing is it's always a cycle that you plan, assess, act, and then come back to the beginning again.
Agile DPIA, basically, right? Integrated.
Yeah.
Seems very obvious to me if you read the text of 35. Yeah.
So from my part, let's say that the Working Party 29 guidelines first say that as a rule, every 3 years you should, the controller should repeat the DPIA, but also every time that the risk changes, and the change can be as a result of using other components or because there are new findings in a societal or economic context. For instance, processing activities on automated decision making that were not considered as risky, but then they appear to be very risky. This should be then taken over by the controller, and the DPIA should reflect that and be repeated in order to be up to the standards. Now, on existing methodologies, there are existing methodologies. There also the also at the level of ISO, there are guidelines prepared on that. There is also examples of EU sector-specific frameworks for DPIAs. This may be used. It is up to the controller to assess whether these provide a comprehensive set of rules to apply for a DPIA. It's unfortunately like that. We don't have the golden standard to assess it. It would be helpful, but we are not, I think, at this stage now.
It would be helpful if the DPA take a position these fall short. Because what you're saying is nice in theory, but it doesn't work in practice.
Can everybody hear this discussion? Otherwise, please take a microphone. I'm very in favor of having an animated discussion, but everybody should hear it.
But Walter, it's not rocket science. Each company who's doing really risk assessment does that on a daily basis.
And DPAs, they have provided some tools to help controllers to make this assessment, the DPIA itself. You may consult some DPA's websites. I can also...
I'm completely in agreement with what you're saying, but still very ivory tower. You're expecting a small municipality to run a DPIA when they introduce video surveillance. They've never done this before. They're not used to corporate frameworks of risk assessments. They look today, let's say, the association of municipalities, how to run a DPIA, and see a template which is clearly not in line with Article 35. Their consultant tells them, you should do this, you should do more. And then the responsible person in the municipality, well, the association said so, and they must have thought this through. And you can point all the way to Article 29 publications. outside data protection circles, nobody reads them because they're not in their natural language. This is not in their world. They want a clear statement from their authorities in that respect. And saying this is ultimately responsibility of the controller is nice in theory. It doesn't work like that in practice.
Okay, clear. Last response, short.
Outside of these papers, just Google how to do a DPIA, and I think that very high you will also find tools already developed by the DPIAs to help you consider
Yes.
and conduct the DPIA.
I think it's a very clear
And
difference of disconnect. Okay, let's go to the next person. Yes, sorry about.
Hi, it's rather a remark than a question. Sorry for, the column is in the way. My name is Philipp Schütz. I'm working for a data protection unit for a big retailer in Germany, and we're actually collaborating with Michael Friedewald in the DPIA project in Germany. My remark is that, we have information exchange also with other companies in Germany, and actually at the moment nobody knows how to do a DPIA, although everybody knows you have to do it somehow. So I'm here also, maybe I'm really interested in information exchange with other business representatives, because we are actually doing this DPIA at the moment, and I'm looking forward to testing the methodology with Michael Friedewald in 2.5 weeks at our company. But for us, it's also really prime, and that also relates to the question we had before, the ivory tower. Right now we are in research from perspective of the data protection authorities, but for us it's really prime that this DPIA is doable in a simple way, and not from a research perspective, but doable for people who are actually not dealing with data protection questions every day. And I think this is also the main challenge we face in this project. Thanks.
Absolutely. Thank you very much for your remark. And I am going to abuse just a very tiny bit my position as a moderator to say, if a company invests so much into data processing of personal data, then it is also to be expected that the investment in these sort of tools are there. And I'm sure if the EDPB would come out with full-scale tools, then the complaint would go the other way, like you're imposing this on us and it doesn't work. So I can imagine this is a real issue, so I'm very happy it comes like this on the table, but it's a very difficult problem. Please, another question or remark? It's not allowed. Okay. In that case, can I ask everybody in one sentence to close off? Katerina to start?
Yes, really interesting panel. I understand the difficulties that there are in practice, because when actually we're talking about risks to rights and freedoms and not just data protection, then I understand that everybody has a headache. But I think that it's important that we understand it clearly what we're talking about and what is at stake here, and
Okay. Thank you.
Try.
One remark, and it does relate to the question. I also work with municipalities on a pro bono basis, so I know what that is. That being said, also I would expect that due to the fact that it's still like a new sort of impact assessment, that there will be like some sort of also perhaps consideration when assessing if an organization has done it properly or improperly. And I also agree with the remark of Mireille that for the big organizations, same as you equally invest in data processing activities, you do have to invest at a 2 level to get it properly done.
Okay. Zoe?
So I think that we are in an area that is evolving. We all have a law, and we have different roles. We have one law and we have different roles: the regulators, the academia, the industry. Each of us has to contribute in accordance to their role to come up to a more converging and convincing model. And this takes time.
Okay. Michael.
Yeah, this was not the first panel on DPIA or PIA at CPDP, and I clearly see we're making progress, though it is still challenging, so it won't be the last one on that topic, I'm pretty sure.
Thank you.
So I think that this discussion about situations where some controllers may not have the ability to really understand the technology that they're using speaks to this difficulty where many of these systems are being developed by one company but then sort of deployed as a service to others who don't necessarily have the insights that they'd need to do a full DPIA. So collaboration between those two needs to happen.
Thank you very much. Thank you very much for your attention, and thank the panel very much.